Hello Year 12s and welcome to the third and final in our series of 3 videos on how individuals or groups can influence law reform. That is, how individuals or groups can influence changes in the law. The word reform means to change. In this video, we'll be looking at how individuals and groups can influence law reform, that is, how individuals and groups can influence changes in the law through the use of the courts. There are 3 things that you need to do as you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. And the third thing you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should include in your summary books. Once you've finished watching and taking notes on this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out your learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to discuss the means by which individuals or groups can influence law reform through the use of the courts, using examples. There are 3 ways in which individuals and groups can influence law reform, that is, changes in the law. These are through the use of petitions, demonstrations, and the courts. Each of the 3 videos in this series will look at one of these ways in which individuals and groups can influence law reform. As you can see from our learning intention, in this video we are looking at how individuals and groups can influence law reform through the use of the courts. Individuals and groups can influence a change in the law through using the courts. They can do this by bringing a case to court in which they challenge the law and argue that the court should change the law. Court cases can be brought by individuals or, in the case of a class action, by a group of people, that is, the lead plaintiff and the other group members. In this video, we will look at an example of both a case brought by an individual and a class action. As we've seen in previous videos, there are 5 ways in which bringing a court case might result in the law being changed. First, in the course of deciding the case, the court might itself change the law by creating a new precedent or by modifying an existing precedent where the case is not already covered by an existing precedent. Second, in the course of deciding the case, the court itself might change the law by changing an existing precedent. This could be because the court is hearing an appeal from a lower court and the court decides to reverse the precedent set by the lower court. Alternatively, it could be because the court is hearing a case after the case in which the precedent was established and the court decides to overrule the precedent because the court thinks that the precedent is incorrect. The court can do this where the precedent was established by a lower court or by a previous decision of the same court. The third way in which a court may change the law is that in the course of deciding a case, the court might be required to interpret a statute made by Parliament. This could be either because a word or words in the statute are ambiguous, as in the studded belt case, or because it's not clear whether the statute was intended to apply to a case such as the case that the court is hearing, as in the Kevin and Jennifer case. By interpreting the statute, the court might itself change the law by adding meaning to a word or words in the statute. However, remember that while a court can give meaning to the words in a statute, it cannot change the actual words in the statute. Only Parliament can change the actual words in the statute by amending that statute. The fourth way in which a court may change the law is through declaring a statute made by Parliament to be invalid. This changes the law because it results in that law no longer applying, and is yet another example of a way in which the court itself can change the law. A court will declare a statute to be invalid where the court decides that Parliament didn't have the power to make the statute. That is, the court decides that the statute was ultra vires, or outside the power of Parliament to make. So, for example, we've previously looked at cases in which the High Court has declared a law made by Parliament to be invalid because that law breaches the Constitution. The fifth and final way in which individuals or groups can influence a change in law through using the courts is where the court itself is not prepared to change the law, but nonetheless suggests that Parliament should change the law. We saw this in the Trigwell case, where the High Court upheld a long-standing common law rule that farmers were not liable in negligence for accidents caused by their stock straying onto the public highway. However, in that case, the High Court suggested that Parliament should look at changing this common law rule, that is, should look at abrogating this common law rule. And, as you know, that's exactly what the Victorian Parliament ended up doing. On this slide, I've given you a recent example of how an individual can influence law reform through using the courts. This is the case of Masson and Parsons, which was a case that was decided by the High Court in 2019. In that case, Robert Masson had donated sperm to his friend Susan Parsons, which Parsons used to impregnate herself. At the time, Parsons was in a relationship with a woman whom she subsequently married. After the child, a daughter, was born, she lived with Parsons and her partner, but Masson took a very active role in the daughter's life and also made a financial contribution to her upbringing. However, when the child was about 8 years old, Parsons and her partner decided that they wanted to move with the daughter to New Zealand, where Parsons had been born. This upset Masson, who applied to the family court for a parenting order under the Family Law Act to stop the couple moving to New Zealand with the child. To be eligible for a parenting order, Masson had to be recognised as a parent of the child. The term parent was not exhaustively defined in the Family Law Act, and so the trial judge had to interpret the word parent and to decide whether a sperm donor could be considered to be the parent of a child who was conceived with their sperm. The trial judge gave a broad interpretation to the word parent, deciding that a parent could include a sperm donor even though that sperm donor was not in a physical relationship with the woman to whom he donated his sperm. However, on appeal, the full court of the Family Court reversed the trial judge's decision because it interpreted the word parent narrowly. The full court of the Family Court decided that a sperm donor who was not in a physical relationship with the woman to whom he donated his sperm was not the parent of the child who was conceived using that sperm. Masson then appealed this decision to the High Court. The High Court reversed the decision of the full court of the Family Court and interpreted the word parent to include a sperm donor who was actively involved in the child's life. As a result, Masson was eligible to apply for a parenting order under the Family Law Act that stopped Parsons and her partner from moving to New Zealand with the child. This is an example of how an individual, Masson, can influence law reform through using the courts. By bringing his case to the court, and in particular by appealing his case to the High Court, Masson was able to persuade the High Court to make law by interpreting the word parent in the Family Law Act in a way that included sperm donors who were actively involved in the life of the child who was conceived using their sperm. Because the High Court is the highest court in each of the state and territory court hierarchies, the precedent that the High Court set as to the meaning of the word parent in the Family Law Act is a precedent that is binding on all other courts in Australia. On this slide, I've given you a recent example of how a group can influence law reform through using the courts by bringing a class action. In 2020, 8 young people brought a class action in the federal court. In that class action, they applied for an injunction to prevent the Federal Environment Minister, Sussan Ley, from approving an extension of a coal mine in New South Wales that was known as the Whitehaven Vickery coal mine. The lead plaintiff's case was that the Environment Minister owed a duty of care under the 1999 Commonwealth Environment Protection and Biodiversity Conservation Act to young people to protect them from the effects of climate change. The lead plaintiff argued that the Environment Minister would be breaching this duty of care if she approved the mine extension. The reason for this was that the digging up and burning of coal results in the emission of greenhouse gases that cause climate change. In other words, the plaintiff's case was that the Environment Minister should not approve the extension of a coal mine which would cause an increase in greenhouse gas emissions and therefore contribute to increasing global temperatures, as this increase in global temperatures would be very harmful for the existing generation of young people who would face the effects of climate change in the future. For example, increasing global temperatures are expected to result in more severe weather events, such as droughts and bushfires, to destroy parts of the natural environment, to reduce food production, to cause flooding as a result of rising sea levels, and to cause health problems through heat stroke and dehydration. The plaintiffs were successful in persuading the federal court to make law by creating a precedent that the Environment Minister owed a duty of care to children. Specifically, the federal court judge interpreted the Commonwealth Environment Protection and Biodiversity Conservation Act to impose a duty on the Environment Minister to take reasonable care to avoid causing personal injury or death to children as a result of the emission of greenhouse gases causing global warming. This meant that the Environment Minister had to take the interests of Australian children into account when deciding whether or not to approve the mine extension. So this is an example of a group of people influencing law reform through using the courts. By bringing this case to the court, the plaintiffs were able to persuade the federal court to make law by creating a precedent that the Environment Minister owed a duty of care to children. However, the plaintiff's victory was short-lived. The Environment Minister appealed the federal court judge's decision to the full federal court, that is, to a bench of 3 federal court judges whose role was to hear appeals from decisions of federal court judges. In that appeal, the 3 judges of the full federal court reversed the precedent set by the federal court judge. These judges decided that the Environment Minister did not owe any duty of care to children, and therefore the Environment Minister could approve the extension of the Whitehaven Vickery coal mine without taking into account the interests of Australian children, and in particular without taking into account the effects of climate change on Australian children. The Environment Minister then approved the extension of the coal mine. You'll recall that our learning intention requires you to be able to discuss the means by which individuals or groups can influence law reform through the use of the courts. On this slide and the next slide, I've included a table that sets out the strengths and weaknesses of using the courts as a way for individuals and groups to influence reforms, that is, changes in the law. You can use this table as a basis for your discussion of the way in which individuals and groups can influence law reform through the use of the courts. Please include this table in your summary books and make sure that you supplement the information contained in this table with notes from your reading of the textbook and from the discussion which follows, which will help you to better explain the points made in this table. The first strength of using the courts to influence law reform is that, as we've seen, challenging a law in a court may result in the court directly changing the law through creating a new precedent, modifying any existing precedent, reversing or overruling an existing precedent, interpreting a statute, or declaring a statute to be invalid. And even if the court itself is not prepared to change the law, it may be prepared to suggest that Parliament should change the law, in which case it could be expected that Parliament will at least consider changing the law. On the other hand, the courts are limited in their ability to change the law. This is because a court, that is a judge, can only change the law in the course of deciding a case. This means that a court can only change a law if a case that raises an issue regarding the law is brought before the court. And a case can only be brought before a court where the party bringing that case has standing, that is, the party is directly affected by the law, and where the party has the money and time to bring the case. If there's no party with the standing, money and time to bring a case to the court, then the court can't change the law. In addition, even where a court does change the law, because Parliament is supreme, Parliament can abrogate, that is, override, law made by a court if Parliament disagrees with the law. The only exception to this is that Parliament can't abrogate the High Court's interpretation of the Constitution. The second strength of using the courts to influence law reform is that even if a party's case is unsuccessful in persuading the court to change the law, the court case might attract significant media coverage. This media coverage might increase the awareness of both Parliament and the public of the need for a change in the law, in which case Parliament might actually act to change the law. However, a party might be reluctant to challenge a law in the court because there's no guarantee that the challenge will be successful. Court proceedings are expensive and time-consuming, and a party will have wasted both money and time if it challenges a law in court and that challenge is not successful. The third strength of using the courts to influence law reform is that judges are independent of Parliament and of the government, and so they can be relied upon to decide a case fairly and based on legal principles. This means that any change they make to the law will generally be an appropriate one. Unlike members of Parliament, they are not influenced by the political considerations that sometimes lead Parliament not to change the law, even where the law should be changed. For example, unlike members of Parliament, judges are not influenced by political pressures such as vocal minority groups, the need to vote on party lines, or the need to make laws that reflect majority views so that they are not voted out of office at an election. Having said this, unlike members of Parliament, judges are not elected. Particularly if the judge is a judicially activist judge, this means that the judge might change the law in a way that does not reflect the views of the majority of the community. As we've seen in a previous video, this may cause the public to lose respect for court-made law. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to discuss the means by which individuals or groups can influence law reform through the use of the courts, using examples. In this video, I have given you the examples of the Masson and Parsons case and the class action in Sharma and the Minister for the Environment. In class, I will give you some additional examples. Don't forget to read the pages from the textbook referred to on the first slide, and if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.